these observations which have been made over 300 paragraphs,
My lord.
are these not to be read
Yes.
as justification for why these norms are prescribed till a law is framed?
But when a law is framed,
When a law is framed,
the law which is made can be tested by our lordship, lord, on the touchstone of Article 14 and 3 my lord, and independence of election commission. संविधान डेमोक्रेसी जिसको हम प्रजातंत्र कहते हैं, उसका आधार ही निष्पक्ष चुनाव और निष्पक्ष चुनाव कराने वाली एजेंसी चुनाव आयोग है। खास आदरणीय कानून मंत्री जी, मेरे आपके और इस देश के लोगों के नहीं बल्कि जो बाबा साहब अम्बेडकर ने कहा, डेमोक्रेसी, रूल ऑफ लॉ, राइट ऑफ इक्वलिटी, सेकुलरिज्म, प्योरिटी ऑफ इलेक्शन, अदरवाइज वुड इंडीड proclaim the presence of independence. Independence must embrace the ability to be firm even against the highest, not unnaturally, uncompromising, fearless, will mark an independent person from those who will pull hold by holding their karma.
26.
And this court, my lord, despite taking various steps, my lord, have not been able to reduce that number.
Not the subject matter.
Yes.
It's confined to the subject.
Yes, my lord, very well, my lord, may I read it.
Tell us, after saying in various paragraphs the need
Yes, my
to
lord.
exclude the executive, why is it said in 315?
Yes, lordship would sign the final name, lord, in 320, para
The
326.
court is laying down norms.
Yes.
Laying down norms for what? Appointment of
Appointment of
election commissioner?
Yes, my lord.
Why does court restrict it only for a particular period till the law is made? The court could have stopped at 314.
Yes.
They are asking you what was the reason that weighed in the
No,
mind
because
of
there
the
was no
court?
law at that point of time.
There was no
Till a
law.
law is made.
There was no law.
Yes,
The
my
court says that there is a necessity
Vacuum?
to bring in a law.
Yes, my lord.
The court is discussing. If you
Yes.
see Mr. Ansaria,
Yes, my lord.
309.
Please, your lordships. 309. In a unique provision of person, we are concerned with the devastating effect of continuing to leave the appointment in the sole hand of the executive or fundamental values as the fundamental rights, as we are also considered of the time the right for the court to lay down the norms. In other words, the vacuum exists on the basis of that unlike other appointments, it was intended all throughout the appointment exclusively by the executive was the mere transit or stopgap arrangement. It was to be replaced by a law made by the parliament, taking away. Now, the law is to be, my lord, taking away the exclusive power of the executive. My lord, this is what your lordship has said. Whether the law meets this test, whether the law has taken
Therefore,
over,
the court finds that it is high time that norms should be laid down.
and it should not be in the hands of the executive alone.
So then why is it said in
315, my lord, that the law will be made, my lord. But law has to be, such law has,
you say that the basis of the order of
Yeah.
the judgment
yes.
has to be removed, which has not been removed.
My lord,
That is what we find
no,
from your.
yes, my lord. Basis
So
of,
this judgment on its bare reading
Yes.
shows that it was only to deal with a particular situation of a vacuum.
yes, my lord. And how the vacuum is to be filled, my lord?
So tell us,
Guidelines are
how
laid down.
extend it-
Please, my lord.
How do you extend it beyond
Yes.
the framing of the law?
Yes.
That this has to be the norm and
It,
the
my lord,
parliament
yeah,
has no
yes.
discretion.
Parliament has the discretion so long as it does not leave exclusively in the hand of the
This is
executive.
your sheet anchor.
Sorry, my lord.
This judgment is your sheet anchor.
Yes, my lord.
It
Yes.
says that Chief Justice should be there.
Yes. I'm not saying Chief Justice, my lord. There has to be, my lord. What I am saying is it cannot be with the hands of the executive exclusively. What the parliament does, my lord, there are various committee reports on various things. But it cannot be in the hands of the executive. As Section 7 says, Prime Minister, a minister nominated by the Prime Minister and leader of opposition. Means, my lord, it is in the hands of the executive and executive alone. I am not saying that lordship would issue a mandate.
We have the parliamentary debates which
Yes, I have, my lord. I will show to you, lord.
let us go to that.
It is in that.
Because it stops till the law is made by the
Yes, my lord.
parliament.
Yes, my lord.
So what did the parliament consider? How was this judgment considered by the parliament?
Please,
Was
lordship.
that-
Would your lordship permit me to place that, my lord? May I read just two more paragraphs and then come to the constituent and the parliamentary debates, my lord? Para 301 and 350 by Justice, my lord Justice Joseph. Yes. However, para 301, however, it is equally clear that 324 has a unique background. The founding fathers clearly contemplated a law and did not intend the executive exclusively calling the shots in the matter of appointment of. Lord, so, my lord, the law which your lordships had declared, such law made by the parliament cannot be, which gives exclusive power to the executive. It does not meet the test of this judgment. It does not meet the test, the ratio laid down by this, which is called out from the Constituent Assembly debates and the various reports of the before and after the Constituent Assembly. And similarly, my lord Justice Rastogi's view in para 353, we declare, may I read that? that as per the appointment to the post of Chief Election Commissioner and Election Commissioner are concerned, the same shall be done by the President on the advice tendered by a committee consisting of the Prime Minister, the leader of opposition in the Lok Sabha. In case there is no such leader, the leader of the largest single party in the opposition Lok Sabha having the largest number, this norm will, and the Chief Justice of India. This norm will continue to hold good till a law is made by the Parliament. As regards the relief of putting the placement of permanent secretariat, etc., not very important.
Still the law is made by the.
Till the law, my lord, I'm not saying that law cannot be made, but such a law cannot be made, my lord, in the teeth of the other findings, which says it cannot be exclusively in the hands of the executive. My grievance is there, my lord, that the constitutional makers, as well as this court in Hon'ble has said, the appointment of the election commissioner or chief election commissioner cannot be in the hands of the executive alone. Now, whether this law, which has been made, has given the power to the executive completely, my lord, and it has, my lord, section 7 is, so it does not, my lord, satisfy the requirement of, my lord, the constitution or, my lord, as interpreted by our lordship, my lord, under the various paragraphs. My lord, what is the law now, my lord? What was earlier, it was, my lord, that the president makes on the aid and advice of the Council of Ministers. Now also, my lord, the president makes on the aid and advice of the Prime Minister and a minister chosen by the Prime Minister. There is no change in the position on the ground, my lord. The position remains the same.
Mr. Sansaria, if you come back to the prayers once again,
Yes, my lord, may I just come back to...
commanding the respondent to make a law,
Yes, my lord. Make a law ensuring free...
ensuring so and so.
Yes.
Does
Further,
the
my lord.
Supreme Court have the power to say to Parliament, make a law?
No, my lord, it has not, and it has
has
not.
not, but
The prayer was...
Direct Parliament to make a law.
But
In the first place,
yes,
was this prayer maintainable?
my lord, it was not granted, my lord. I will not say no mandamus can be issued to the Parliament, my lord. The law is very clear. There's no mandamus can be, it can be, some vacuum can be filled till a law is made, but that law has to be valid law. I cannot, that's like, my lord, in PUCL and ADR case, other case I have separate. The mandamus was till a law is made, you must declare criminal antecedents, your assets and liabilities. Law is made, you don't need to declare. And that was struck down in PUCL case. Only on the ground that the basis of the judgment, you cannot undo it by legislation, so-called legislation, by retaining the same position. Lord, here also, the position remains the same. Prior to making of the law, it was the president who makes on the aid and advice of the Council of Ministers.
To assist Mr. Hansaria, my lords, para 308 refers to the mandamus point.
308.
Yes, my lords. 308 and 309.
My lord, may I read, my lord, para 5. There are batch of petitions. In one of the prayer, para 5, in writ petition so and so for ADR, issue appropriate direction order declaring the practice of appointment of CEC and EC solely by the executive as violative of 324 and Article 14. And that is what your lordship has done. And B, direct the respondent to implement an independent system of appointment of EC, etc. on the line of 255th report at Dinesh Goswami Committee report, etc. And this is what your lordship has said. The various committees have said, my lord. Dinesh Goswami Committee has said, the Law Commission report has said, my lord. It cannot be exclusively, my lord. Who can be? Parliament will take a call. But it cannot be, my lord, that the executive exclusively had it. 308, would your lordship kindly see? Yes. Lord, as your lordship has said, my lord.
Prerogative of the Parliament
Yes, my lord.
to enact the law.
Yes, my lord.
Courts cannot direct Parliament to make a law.
That prayer is rejected, my lord, in para 308. No doubt.
Now, for 7 decades,
Yes.
324(5)
Yes.
on paper only.
Yes, my lord.
Court felt that it is high time
Yes.
that certain norms should be laid down,
Yes.
and these norms should be followed till such time a law is made by the Parliament.
Please, your lordship.
Right? The court was conscious
Yes.
of its limitation.
Yes, my lord.
So, these observations which have been made over 300 paragraphs,
My lord.
are these not to be read
Yes.
as justification for why these norms are prescribed till a law is framed?
My lord, till a law is framed, it is, my lord, these norms have to be followed. But when a law is framed,
When a law is framed, then can you say that these norms have been followed,
Lord,
have not been followed?
Lord,
Therefore, the law is
no. These norms flow from the constitutional mandate. Lord, these norms, which are laid down by your lordship, Lord, in various paragraphs, are derived from the constitutional mandate that it cannot be left to the executive alone. That is the mandate of your lordship's court. That if it is left to the executive alone, there is a reciprocity, there is no independence. So you have to have an election commission which is independent. And if you leave it to the executive, the independence is compromised. That is, and if the present, my lord, if the present law which has been made, it is the same position. My lord, what was there is no difference whatsoever in my respectful submission between the law which was earlier prevailing, except that now it is a parliamentary legislation. Earlier, under the rules of business, it was being done under the same thing, my lord. Under the rules of business, there was no different. The president does it on the aid and advice of the council of ministers. And it is done instead of the entire council of ministers, the prime minister and a minister chosen by him recommends. And that has been made. There is no difference which has been there, my lord. The law which is made can be tested by our lordship, my lord, on the touchstone of Article 14 and 3 to allot and independence of election commission. The law minister presents it. And at 111, Randeep Singh Surjewala, 111, no? Because the main opposition is by, my lord, speech is given by Randeep Singh Surjewala. It's in Hindi, partly in English.
Well, will you read?
May I read it, my lord? सभापति महोदय, आदरणीय मंत्री जी ने कहा कि सुप्रीम कोर्ट ने कई निर्देश दिए हैं जिसकी चर्चा बाद में करेंगे। ठीक है, चुनाव आयोग को आधार प्रजातंत्र की शुचिता, प्रजातंत्र की निष्पक्षता है। संविधान डेमोक्रेसी जिसको हम प्रजातंत्र कहते हैं, उसका आधार ही निष्पक्ष चुनाव और निष्पक्ष चुनाव कराने वाली एजेंसी चुनाव आयोग है। आप जब भी आप चुनाव आयोग की बात करेंगे तो ये चार शब्द निष्पक्षता, निर्भीकता, स्वायत्तता, शुचिता आपके जहन में जरूर आएगी। सर, आप सभापति जी हैं और कानूनविद के तौर पर सुप्रीम कोर्ट के एक काबिल वकील भी हैं। 140 करोड़ लोगों के इस देश में किसी व्यक्ति के जहन में ये चार शब्द आएंगे। ये कानून है आज माननीय मंत्री जी और सरकार लेकर आई चार शब्दों को बुलडोजर करके बुलडोजर के नीचे कुचलने वाला कानून है। ये मेरा विनम्र आग्रह है। सभापति, इसके पहले मैं भी इसके प्रधान का चर्चा करूं। इंडिपेंडेंस ऑफ इलेक्शन, जिसे अंग्रेजी में कहते हैं अवॉइडेंस ऑफ इंटरफेरेंस ऑफ एग्जीक्यूटिव, हमारी इलेक्शन मशीनरी इन दोनों बातों से प्रेरित होगी। ये हमारे संविधान के निर्माताओं ने कहा था। काश आदरणीय कानून मंत्री जी मेरे, आपके और इस देश के लोगों के नहीं बल्कि जो बाबा साहब अम्बेडकर ने कहा था और संविधान सभा में जो चर्चा हुई थी उस पर एक डाल लेते तो शायद ये कानून को अभी तक वापस ले लेते या बनाते ही नहीं अथवा लेकर ही नहीं आते। निष्पक्षता, इंडिपेंडेंस, निर्विकता, ओके, इंडिपेंडेंस एंड सैंक्टिटी। नो, हिंदी वर्ड इज निष्पक्षता,
Nirvikta means fearless.
I'm so sorry, fearless, स्वायत्तता,
Independence and sanctity.
and suchita.
Independence and sanctity.
Yes. Now, would your lordship kindly come to my lord again, Mr. Surjewala? Yes, it violates and negates the rigor and affirmation by the Constituent Assembly by Baba Saheb Ambedkar and other individual honorable members of the Constitution. It goes against the very spirit of the Constitution that it enriched in Article 14. It completely negates and subjugates the Election Commission to the authority of the executive. It does away with, and I respectfully say willingly, and if I say maliciously, the judgment of the Supreme Court in toto. That is why the law is per se like stillborn child. Thirdly, I want to point out, जैसा माननीय उच्च न्यायालय ने कहा, आर्टिकल 14 जो हमारे मौलिक अधिकार का हिस्सा है, जो सत्ता में बैठे हुए सत्ताधीशों के बेलगाम कार्यों पर अंकुश लगाने का सबसे बड़ा तरीका है, यह आर्बिट्रेरी पावर। यह पूरा कानून उस आर्टिकल 14 के लेटर इन स्पिरिट के विरुद्ध है। इसके मौलिक अधिकारों का उल्लंघन है। जैसा माननीय उच्च न्यायालय ने कहा, सभापति जी, अपॉइंटमेंट कमेटी है, अब एक एम्प्टी फॉर्मेलिटी है। इफ आई कैन यूज द वर्ड अपॉइंटमेंट कमेटी, क्या है? माननीय प्रधानमंत्री जी और माननीय प्रधानमंत्री के मनोनीत किए गए और उनके एक मंत्री हैं। गांव की एक कहावत है, क्योंकि ग्रामीण पृष्ठभूमि से हूं और आप भी हैं, आधा बांटे रेवड़ी मुंह, अंधा बांटे रेवड़ी मुंह में अपने को दे। Sorry, not to reading Hindi.
Blind.
Andha.
Andha means
Blind.
Andha means blind. What is Bate Revri?
Please
distribute the.
Please wait. Sir, you please tell us what is the meaning.
Well, I close my eyes, I am giving it and I am giving it to myself.
Batman is distributing sweets.
He close his eyes, my lord, and give it to himself.
Oh, he's giving to his people.
मुड़कर अपने को दे।
Everybody is a small sweet.
अपने को दे, not अपनों को
What
दे।
you say that andha means the blind person when he distributes, I don't know how far that is relevant,
Eh.
because a blind man cannot distribute to his own people, because he would.
No, it's not in, अपने को दे, not अपनों को दे नहीं है, अपने को दे, खुद को ही दे.
So then he.
हाँ, he is giving it to himself. That's why it is the same. That is what the next line says. If the Prime Minister and his minister are going to be majority in the committee, then why have the committee?
He himself appropriates.
Yes.
That's the meaning.
That is not the answer. If the Prime Minister and Minister are going to be the majority of the committee, Prime Minister and his minister are going to be the majority of the committee, then why have the committee? Let the Prime Minister appoint everybody, then why have even the law? It is an empty formality. Now, Lord, may I read last 3 lines? I am saying it with a sense of responsibility. For them, do not want an independent election commission, CEC or OC, they want a pocket bureau. उन्हें एक जेबी चुनाव आयोग, 1 pocket, की आवश्यकता है. यह कानून एक जेबी चुनाव आयोग का गठन करेगा. आप जेब से चुनाव आयोग निकालेंगे और आप जब आप चाहेंगे जिस पर प्रजातंत्र के साथ वही करेगा. इस कानून का फाइनल मतलब यही है. यह पिक एंड चूज का फॉर्मूला होगा. सर, आई रेस्पेक्टफुली ऑल्सो से दैट इट डज नॉट पास एनी काइंड ऑफ constitutional muster. We have to be aware. This is in August House. After all, we have to be aware as to what we see we are doing or saying and what we are passing. This is manifestly arbitrary. These are ill-conceived attempt. This law is ill-conceived attempt to at the consolidating undue total executive control over the elected body, that is election commission. This process is arbitrary, intent is malicious, and result is disastrous, if I can say so. That is what going to happen, sir. And I want to take the liberty of last time quoting the Supreme Court judgment. Then the Supreme Court judgment is quoted, my lord.